Yesterday, I got a message from this gentleman saying that India's laws are so arbitrary and gender biased. I asked him why. He says that he read this news report that this 28-year-old girl in Dwarka in New Delhi crushed an elderly couple and was immediately released by the police, was granted bail very, very quickly, and now she is out. And the man lamented the gender biased state of affairs where a woman is considered innocent all the time, and by default, every man is considered a perpetrator. I didn't think much of it, but then people started tagging me in these articles as well, and I had to make this video then because I hate propaganda. Propaganda by the left, propaganda by the right, propaganda by the feminists, and propaganda by the men's rights activists. I don't know these people who are creating these stories and who are circulating them. Do they know or not the difference between a bailable and a non-bailable offence? Because it is clearly stated everywhere that the police was kind enough to at least divulge which sections this lady was charged under. She was charged under section 304A as well as section 279 of the Indian Penal Code. 304A says that whoever causes death by a rash or negligent act shall be punished with 2 years of imprisonment, and 279 says rash or negligent act in public endangering the safety of others is punishable with, I think, up to 6 months, 3 months, something like that. But more important for the purpose of this discussion is the fact that both these offenses are bailable. I have on numerous occasions and numerous videos talked about how in a bailable offense, bail is available to you as a matter of right. If you have to be given some context, a lot of men lament that they can be accused arbitrarily without any proof of sexual harassment by a woman, and even then I have to explain to them that 354A of the IPC is also a bailable offense, which means that you cannot be arrested by the police when you're accused of sexual harassment. Of course, there is an arrest which happens, but it happens on paper. So in this particular case, the police took this lady to the police station, said that we prima facie, on the face of it, we see that you have committed an offense punishable under section 304A as well as 279 of the Indian Penal Code. We hereby put you under arrest because it's a cognizable offense, which means that the police have the right to investigate into the matter. Say, in contrast to an offense such as defamation, where the police do not have the right, the power to investigate into an offense of defamation. You need to file that in court. So the police say this is a cognizable offense, therefore I have the authority to arrest you. And then the police say right there and then that because this is a bailable offense, I hereby grant you bail as well, which means that you need to just sign this document saying that you undertake to appear before the police as well as the court whenever you are summoned to appear before them. You also need to arrange for a surety, that is a friend or a family member, who will also give on paper the undertaking that I give this undertaking that this person who is an accused right now before you, he will appear whenever called. If he does not appear, then I will stand to lose a sum of rupees, say 15, 20, 25,000, whatever the court or whatever the investigating officer deems fit. However, if we talk about the actual trial and whether this lady can get away with it or not, there is clear proof the persons have died. In such a circumstance, it is very difficult for the lady to now be able to escape justice. In all probability, she will be, after a fair trial, she will be sentenced to adequate amount of imprisonment. Is it good enough? Causing death of 2 people, go to jail for 2 years? Maybe, maybe not. But let me tell you this rash and negligent driving is something that you also have to talk about drunken driving, because this is usually what a person is charged with. And in this circumstance, it is not just 2 years of sentence, it is not just a bailable offense, because the Supreme Court in its wisdom, and correctly so, has stated in the past that if a person is doing drunken driving and then he kills someone or hurts someone, we are going to, at least when they kill someone, we are going to assume that this person had the necessary intention to cause the death of the person, which will be commensurate with section 302 of the IPC, which is murder. The court says that if you are doing drunken driving, you must be presumed to have sufficient knowledge that you could in all probability be killing someone when you are doing this rash and negligent act after drinking. And that is why if a person is found doing drunken driving, then he is not just charged with section 304A but also with 302 of the IPC, and there is no bail, at least not immediately. It is a non-bailable offense. The person has to go and then apply before the sessions court. Because it's a sessions triable offense, the person has to go and apply for regular bail before the sessions court. Coming back to the point at hand, let us not bow down to propaganda, be swept away like sheep. Let us think for our own selves with our own minds.